Before we get started, we'd like to thank Nationwide for sponsoring this episode of Let's Get Surety. When you partner with Nationwide Surety, you know you're working with a strong and stable carrier that has a wealth of experience. Nationwide Surety Operations specializes in both commercial and contract surety bonds to support local, regional, national, and international customers with operations in the United States. For more information on Nationwide Surety Solutions, visit nationwide.com/surety.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks for joining us for this episode of Let's Get Surety. We are recording this episode on November 30th, and we're discussing a timely topic, the FAR clause, and the vaccination requirements for federal contractors. To discuss this important topic, I have with me my co-host, Mark McCallum, CEO of NASBP. Hey, Mark, thanks for being on with me.
Hi, Kat. Great to be back on such an important topic.
I know. It's good to have you on with me. And we have two guests with us who are experts to discuss this issue with us. We have Jake Scott, a partner at Smith Curry Hancock, LLP. Hey, Jake.
Hello. How are you today?
Good. It's great to have you on.
Great to be here. Thank you for having us.
We also have Alex Gorlick, who's an associate with Smith Curry Hancock, LLP. Thanks for being on, Alex.
Thanks for having us, guys.
We're happy to have you both. Before we dive into this topic, Jake, do you want to start off and tell us a little bit about yourself and a little bit about Smith Curry?
Sure. I think I should say, just for purposes of keeping within the lines of attorney advertising ethical rules, I might not be considered an expert in this topic. I do specialize in government contracting. I think probably 99% of my work is in government contracting, always has been. Smith Curry is an Atlanta-based construction and government contracting firm. In 2021 was voted the construction law firm of the year by Chambers. So we have that going for us. We've got about 60 attorneys all told through Atlanta, Washington, D.C., Florida, the Carolinas, and California and Virginia. And so I primarily practice government contracts where it intersects with construction. I have some independent government contracting clients as well. But that's what I've done. That's what I've always done. And it's what I enjoy doing.
Awesome. Alex, can you tell us a little bit about yourself as well?
Absolutely. Much like Jake, much of my practice, most of it focuses on government contracts. I've actually came from the government and was a contracting officer in my past life. So this is a topic, anything to do with government contracts is well familiar to me. Happy to represent government contractors in all sorts of compliance matters, protests, and anything that comes up.
Well, since you both have clients primarily in government contractors, I'm sure this is not your first time talking about this topic.
That's right.
I know this is pretty top of mind. What's going on, and the deadline is quickly approaching on December 8th.
That deadline has moved. Surprise, right? So is everybody else. The deadline has now been moved to January 18th for full vaccination for federal contractor employees, which means full vaccination means 2 weeks after the last of the shot course. So if it's Johnson & Johnson, that's 2 weeks after the one shot. If it's Moderna or Pfizer, 2 weeks after that. So by January 4th, government contractor employees will need to have all of their shots completed. So Alex and I were talking a little bit beforehand, and we thought we might want to start with a little bit of form to this and define a few terms that are important to the entire construction of the requirement. And if without an understanding of those, it's going to be very confusing to start the conversation in any meaningful way. So if you don't mind, we have a couple of definitions we'd like to get into.
Yeah, actually, that sounds great.
Even before that.
Jake, can you kind of give us a little bit of background? What was the impetus for this FAR clause to come into being? Was there an executive order or something along those lines issued?
It was Executive Order 14042. I don't have the exact title on hand, but it was related to protecting the workforce from COVID. And so that was issued in, I believe, early September of this year. And by about October, the Safer Federal Workforce Task Force guidelines, which are the actual meat of the requirements, were published after approval by the Office of Management and Budget. And that is what is being incorporated into contract by way of, currently they are class deviations based on a FAR and DFARS clause. We can talk about that in a little bit. So this happened very quickly.
Yeah, the task force is the administration's go-to on this subject matter. Is that correct?
That is right. They were established earlier for some other more general workforce safety issues, but very quickly, at least from observation, it appears this sort of took over their reason for existence. I think it's kept them very busy.
Yeah, it seems like also their work is almost, you could say, just begun. Things like developments keep happening. Is that a correct statement?
Yes, that's absolutely true. When I mentioned that the deadline for vaccination moved to January 18th, it had previously moved from December 8th to January 4th, which was pretty widely publicized. But then in early November, the task force modified its guidelines, but didn't really make a big deal about it. And the only change to those guidelines was that date from January 4th to January 18th. And that's obviously continues to still surprise some people. So, I think they're working very furiously to keep up with all of the changes that are going on.
And were there reasons why they delayed the deadline for this? I imagine it kind of hit people as somewhat of a surprise, perhaps?
The requirement definitely hit as a surprise. Like I said, the executive order came out in September. Here we are, the last day of November, so about 3 months, and we're looking at a wholesale change to the face of contracting, both civilian and defense. I don't know what the official position on why the change was. What I can tell you is almost certainly it had a lot to do with private sector pushback and the complications that I think in a fast-moving program weren't totally gamed out when the executive order was issued, and even more importantly, when the guidance itself was issued. There are some significant administrative burdens on contractors, and I think that both the administration and the Safer Federal Workforce Task Force probably somewhat underestimated the apparent pushback they're getting from employees, and as a result from contractors as well, who are afraid of losing those employees.
Well, you were going to contextualize things with some definitions, I know.
Yeah.
So
before we even do that, though, I want to start. So there is another sort of vaccination/testing requirement that came out right about the same time. The executive order on that was issued the same day as this executive order, and that was for employers in the private sector with 100 or more employees, and not just contractors, for any private sector employer. You may have seen that referred to as the OSHA Emergency Temporary Standard, or the ETS. That has been stayed by a federal court pending several legal challenges that have been consolidated. So its future remains uncertain. This contractor vaccination requirement and the ETS are entirely separate. So we get that question a lot. Now that people will ask, now that the OSHA requirement has been stayed, we don't have to comply, right? And the answer is that's not correct. They're two separate requirements. Compliance with the OSHA ETS as it was written would not have met compliance requirements for the contractor mandate in any event. But for the time being, there are some existing legal challenges that are making their ways through the courts to the contractor vaccination mandate. So far, to my knowledge, none of them has resulted in any kind of an injunction against enforcement of the requirement. So for now, we are on track for still having a January 18th vaccination deadline. So let's start with a couple of definitions. And Alex, I don't know if you want to start with a couple of them to put it in context for us.
Sure. I think it's helpful to kind of start out, with what is a covered contract that this vaccination requirement is really going to apply to. And the general thought, the general guidance is exceptionally broad in terms of what this applies to. The contract really is pretty much any agreement between two or more parties that creates enforceable obligations under the law. And then the guidance will actually go in depth in listing a number of different contract types that this applies to, including everything from modifications, contracts, regular contracts, lease agreements, pretty much every kind of contract that you can get from the government is addressed by the guidance as a contract or contract-like instrument.
Right. So, Alex, this is directed at federal contracts, federal contractors, and then it then flows down, if I'm hearing you correctly. You said it's very broad. Are there any types of contracts that are not covered? For example, are supply contracts covered, or contracts being performed overseas?
Well, it's interesting that you asked that, because there is actually some language in the guidance, and this traces its way back from the executive order, which essentially suggests that the guidance doesn't apply to what the guidance refers to as products. Now, products aren't actually defined in the guidance. But the FAR, which is, of course, governs most federal contracts, procurement contracts, defines products as supplies. And what we have seen with at least one particular contractor, Huntington Ingalls, is that the government has, in some instances, specifically with them, determined that contractors that just provide products, so supplies, may not be covered by this vaccination mandate. That said, that is ultimately a very limited exception, because the guidance also says, also strongly encourages the agencies to incorporate the requirement vaccination mandate even in contracts that do not that aren't directly covered by the guidance. So even if really you're pretty much hoping for the goodness of the agency's heart in assuming that it doesn't apply to you, even if you just supply products.
So it sounds like the default should be, I need to know about this if I'm doing business with the government, particularly in the construction arena, where there might be a mix of services and supplies. I still need to know about this and comply with what's being required.
Yeah, absolutely.
Is that fair to say?
Mark, just to follow up on part of the question you asked earlier, this doesn't apply to contracts being performed outside the United States. It also doesn't apply to employees of covered contractors who are located outside of the United States, even if the contract is being performed within the U.S. Now, that's a pretty tiny minority of employees, but that is technically the case.
Great. So it sounds like, again, the vast majority of contracts are going to fit within the regime of this order and the requirement.
The mandate was written very cleverly. I got to give the government a lot of credit here. They wrote this in such a way that makes it very, very difficult for contractors and employees alike to find a way through the vaccination requirement. So another definition that we have is a covered contractor, and that one's pretty simple. That's any federal contractor that has a covered contract. And the way you know your contract is covered is if it has the clause incorporated into it. So the FAR clause is going to be FAR 52.223.99, and the DFARS clause is 252.223.7999. Right now, those are being implemented by class deviation through specific agencies until the FAR and DFARS clauses are formalized. All those clauses do, though, it's innocuous on its face. It says these incorporate the guidance of the Safer Federal Workforce Task Force and the FAQs as amended during the course of performance. So it is interesting in that it puts a burden on contractors to continually monitor the Safer Federal Workforce Task Force guidance as well as the FAQs, because those FAQs and the guidance will be applicable to the contract throughout the life of the contract, even if it changes, which is that will be an interesting legal challenge. Generally, as lawyers, we consider that to be an illusory promise, promising to do something that you can't define or you don't know what it is. We haven't seen any of those yet, but I'm sure it's on its way. It'll be a case I would be very interested to see. I don't want it to be any of my clients, frankly, because it's a total unknown. And Alex, maybe you can tell us what a covered contractor employee is, because this one has generated a lot of questions for us here.
The covered contractor employee is really any full-time or part-time employee of a covered contractor. So pretty much if you work for a covered contractor, you're likely to be a covered contractor employee. In fact, the requirements of the guidance actually extend even beyond contractors that are working on the covered contract specifically. So essentially, if you're an employee that works for a covered contractor, but even if you don't work on a government contract, this guidance may still be applicable to you with certain exemptions aside.
So if a contractor has a workforce, let's say there's a manufacturing or fabricating facility, and there are some employees devoted to work on the quote covered contract and some devoted to, let's say, private contracts, are those other workers swept into complying with this as well?
Yeah, so the way the guidance is written, it even applies as far as remote employees that work for a covered contractor. There is an exception within the guidance for contractors that can have sort of separate facilities, separate locations, separate buildings, and can separate their workforce that way. Obviously, this is much likelier to come into play with larger contractors that have such separate facilities and also can just handle the administrative burden, because there's certain things that you have to jump through in order to meet that exception.
So so you're a covered employee. You now need to make sure that they're vaccinated by a certain date. Are there any exceptions or exclusions to an individual being vaccinated?
There are. And Mark, I want to just go back real quick to something Alex said. And your question was specifically if you have a federal project and a commercial project or a private project. So it really depends on where the employees are located. And this falls under the contractor workplace. Part of the definition of an employee is an employee working on or in connection with a federal contract. So the on is the easy part. That's like you said, a federal project crew, say on site. The in connection with is trickier. That's going to bring in people whose jobs are not directly related or not directly for the contract, but whose performance is necessary for the contractor to perform the work. So we're talking payroll, HR, executives, likely. We haven't seen that sorted out yet, but the position that we have taken, or at least I have taken, is that if you would like to say that your executives are not necessary for your company to function on a government contract, be my guest. But my guess is that nobody's going to do that, which means that they're going to be covered employees as well. Now, a covered employee is anybody also if they are in a covered federal or a covered contractor workplace, which is a workplace wherever any covered employees are working. Even if the person is on, say, a private contract, say it's a foreman, but he's got to come back once a week to turn in payrolls, et cetera, he's got to be vaccinated.
Right.
Now, his crew on the project, probably not, unless they're coming into the office. But what the standard is that employee likely to be there? So it can stretch pretty far.
Yeah. Well, I have a question too. So, with construction, so much of it is done outside in the open air. Do the restrictions still apply? If you're strictly an
Yes,
outside employee who works in
yes,
an
they
outdoor
do.
environment?
And it even so, there are two other areas of this requirement that haven't gotten as much airplay as the vaccination requirement. One of them is masking and social distancing. And those are just what they sound like. It's the same stuff all of us have been dealing with for the last couple of years. In indoor settings, generally everybody needs to be masked and social distancing where possible. And it's a little more detailed than that, but for our purposes, you still have to mask and social distance indoors. But one of the tricks with this is that the contractor has to monitor the CDC's community transmission rates for the location of the workplace. So if it's a high community transmission area, even vaccinated folks have to be masked up inside, and non-vaccinated people will have to be masked up outside as well. So that's something this puts a lot of burden on contractors to continually monitor this, which brings in the third element, which is a COVID-19 workplace safety coordinator. Every federal contractor has to have one of these. Now, it can be somebody that they have assigned from their existing staff, but depending on how many contracts the contractor has, they may need to hire an independent person or a new employee just to cover these roles.
Does that person have to have special training?
According to the guidance, no. Frankly, I'm not quite sure what kind of specialization they would need, which is probably the same question that everybody else has, because there probably is something that would be useful. Unfortunately, the government has declined to provide any insight into what would be useful. I think right now they're just trying to get bodies in control of this. Now, Kat, you asked about, or somebody asked about specific exceptions. And there are two exceptions. There are medical exemptions or disability accommodations under the Americans with Disabilities Act. And there are religious exemptions under Title VII of the Civil Rights Act of 1964. And that's it. Those are the two exemptions to the vaccination requirement. Now, the medical route has probably pretty much been foreclosed. The CDC has identified a few specific times when vaccinations are contraindicated. Most of them are temporary after receiving certain monoclonal treatments and things like that. Allergies, so pretty uncommon instances. So that leaves the religious exemptions. Now, the government has not provided any guidance on how those exemptions should be evaluated or determined. They leave that up to the contractors. And that has been a source of quite a few questions that we're getting. Employees threatening to request religious exemptions. And employers are worried that they're going to be on the hook for granting a religious exemption without having, they're not religious specialists. They're worried about being put in a position to judge the sincerity of somebody's proclaimed religious beliefs. So that is still being worked out. We have not seen that come to fruition yet. One of the reasons for that, really, in general, is that the government has tried to impose the modification bilaterally onto just about every contract out there. Most agencies are going pretty full steam on this. But we haven't, the actual implementation of the requirement has been pretty calm. We're not seeing a lot of fighting. We're not seeing a lot of agency enforcement at this stage. I was at a conference recently, and some representatives from a federal agency said, we're treating enforcement much like we do with the Drug-Free Workplace Act or requirement, which is that we're going to trust you, which garnered some chuckles from the crowd. And enforcement is a big question. Generally, as long as the prime contractor flows the requirement down to its sub and the sub to its sub tiers. Unless there is a good reason for them to believe that there is non-compliance by any of the lower tiers, each tier above can rely on the representations of its subcontractors.
There are also, just to mention, some two very limited exceptions. As Jake mentioned, the religious exemption and the medical exemption really are the primary ones. There's also, but there are two kind of more fine-tuned and narrow situation. There's one for emergency use, essentially a 60-day exception that in some cases the government may grant, where the contractor has an urgent mission critical need and is simply unable to get their staff fully vaccinated in time. Of course, you will ultimately need to get that exemption approved. So I wouldn't count on having that necessarily without at least very particular circumstances. And there's also a specific circumstances exception which can apply in which really is just specific to mask wearing and social distancing, but some examples that the guidance gives are, for example, situations where the masks can't be worn due to the fact that they're going to get wet or provide difficulty breathing. Again, the guidance does say, though, that any such exemptions have to be provided by the government in writing, and they have to be approved, beforehand.
Well, and Alex, as a former contracting officer, it seems like documentation would be very important. Can you tell us how contractors can go about making sure that they have proper documentation to prove that they're complying?
Yeah, absolutely. I mean, really, the onus is going to fall on what Jake has described, the COVID vaccination point person, so to speak, for the company. The guidance actually provides a specific list of vaccination documentation that can be accepted from an employee. So it's things like a copy of the immunization record, a copy of those COVID-19 vaccine cards that many of us are so used to seeing, medical records documenting the vaccination, state records, and essentially official documentation provided by the vaccination providers. If you're seeking, if you end up having employees that are going to be seeking exemption, they're obviously going to need to provide documentation of those things as well. But ultimately, it really is going to fall to that sort of COVID-19 point person to make sure that they are aware of the latest and greatest in guidance that's out there in terms of what documentation is appropriate.
One of the things,
have it from their employees.
Sorry, Mark.
Well, I was just going to ask, so in terms of documentation and keeping that documentation, is there guidance on the length of time within which you must keep that documentation?
Mark, it's supposed to be treated the same way as medical files. So subject to HIPAA, segregated from other personnel files. Right now, there is no limit on the time that the requirement will be in place, and the guidance doesn't give any indication that the maintenance of the proof is temporary. So for the time being, that documentation does have to be kept until otherwise noted. In any event, it would have to be kept for the same period as documents related to a contract in any other setting, generally until 3 years after close. So one thing related to documentation, and this is something that we get asked about a lot, is contractors who are currently performing on federal facilities have a separate requirement that they are subject to now, and it's a vaccination or testing regime. But rather than provide proof to the government, the contractor employees are required to complete an attestation that they have either been vaccinated or that they have received a negative test within the previous 3 days. Those types of attestations are not sufficient to meet the vaccination proof requirements under the mandate. So that has been surprising to some folks, but that is just the way it is. It's very clear that those attestations are insufficient.
I wanted to circle back to what you said earlier about the burden to keep current on FAQs and guidance and so forth. So if I'm a contractor, besides having excellent attorneys like yourselves, where do I go? Is there a website? Is there an area that I can keep going back to see what is the most current guidance from the government?
There is. It's the Safer Federal Workforce Task Force website, and it's saferfederalworkforce.gov. And there is a special tab just for federal contractors. And if you click on it, it's got the most recent version of the guidance. It's also got a copy of the executive order. It also has a link to the FAQs, which is where, frankly, a vast majority of the very useful information comes from. It asks the questions that people really want to know the answers to, in terms of some of the more specific and complicated types of questions that represent what's actually happening in the real world.
In fact, it's certainly worthwhile, I would say, to make sure that any contractors that do try to follow this on their own stay aware of the FAQs, because a lot of the FAR clauses, the FAR deviation clauses that are incorporating the mandates actually incorporate the FAQs as part of the requirements. So anything that's in there really is as good as additional guidance.
Obviously, this probably there are some contractors already performing. And this may be another separate podcast, but I wonder if Alex and Jake, you could touch on how should contractors be looking at the costs of adhering to the order and complying? What should they be doing about that? Should they be documenting any additional costs, that type of thing?
That's a really good question. And that, frankly, is one of the biggest questions that we get. So I think there are two scenarios you have to look at here. Basically, any new contract or any new solicitation that's coming out now is going to have this clause in it already. So you can price it in, right? You're not going to be getting a modification or being able to get an REA paid on the basis of these requirements. The challenge that we're seeing is for existing contracts, which don't have to have the clause in them. The agencies are trying very hard to modify those contracts. They are generally permitted to do that. Now, we've had different agencies tell us a number of things. The modifications are generally bilateral. None of the agencies that we have spoken to or heard from have said that they will accept any type of reservation of rights for time or cost related to this, which raises the question of, is that really a bilateral modification? Some agencies have said, if you don't sign the bilateral mod, you can perform until the next option period comes up, at which time we're legally obligated to insert it, or extension. Other agencies have said, if you don't sign the bilateral mod, we're going to terminate you for convenience. So it runs the gamut. In any case, you're not going to be able to reserve your rights. Now, some of the agencies have said, we've told our contractors to consider those REAs, even though it's a no cost, no time REA. That also, at this conference I attended, received huge chuckles because anybody who's submitted an REA on a no cost, no time mod knows how much sand they got told to pound, right? That said, there are some legitimate costs that contractors should be tracking. And Mark, I think you hit really right on the head of probably my biggest piece of advice to any clients in any situation, not just for this, but ever, is document everything. Don't think you're going to remember this 6 years down the road when you're at the Board of Contract Appeals trying to testify about it with no written proof, because number one, you're not going to remember. Somebody else is going to remember differently than you. And number three, there's no proof that it happened. So so there's some initial costs for compliance. You're going to have to do things like employees taking time off to go get vaccinated. Plus, a lot of us probably know that at least sometimes that second shot can be pretty nasty. It'll knock you out for a day or two. So you need to pay for that time off. You should, right? So there's that. We've talked about it a little bit. There's a fair administrative burden here. whether it falls on your HR department or general administrative, but tracking the vaccination proof of all the employees, making sure it's handled appropriately, handling any of the exemption requests is another one. And then you've got the new COVID-19 workforce safety or workplace safety coordinator, which I can imagine in a lot of scenarios will be actually directly inside the HR department if it's not just somebody already in the HR department. You're going to see other things, extra manager time probably for handling some of these scenarios, as well as some labor costs, whether that's from things like managers having to spend more time on counseling employees, or even picking up where employees have either left or been terminated for a refusal to be vaccinated. And we have had clients that are ready to impose the vaccination mandate. They are glad to see the legal requirement, which gives them some cover. And still they are expecting to lose, in some cases, 20, 30% of some of their workforces in certain locations. They're ready for it, but it's going to cost them money, right? And so that's another thing. Subcontractors, this applies to every tier of subcontractor until you get to a supply contract. We're finding, particularly in the construction trades, vaccination rates hovering somewhere around the 30 to 40%, which that anecdotal, I'll give you that, but that's what all of us here in the firm have generally been hearing, with lots of so far unrealized threats that if employees have to be vaccinated, they will walk. Now, whether that will come to be is yet to be seen. But for a smaller subcontractor, it may be that the entire subcontractor will be unable to continue performance, which means the prime is going to have to find a new sub, which opens the prime up to LDs and breach or default, all kinds of risks there. And there's not a real good mechanism other than an REA or a request for a change to address that sort of thing.
So can I ask you, Jake, and Alex to answer perhaps an uncomfortable question, in that it's asking for conjecture. So you mentioned that there's a low vaccination rate in the labor force for contractors. We know that there's already not enough workers, in the construction realm for probably the demand that exists now and will exist. So how do you think that will play out in the administration's enforcement of these requirements in the future, particularly given that they want to start getting infrastructure, contracts and other contracts underway?
Well, we've seen a little bit of how this is going to play out already in changes to the guidance. When the guidance first came out, the deadline was December 8th for vaccination, would put your actual last day of getting a shot, I think, at November 24th. And it became pretty clear that was going to be difficult, particularly for existing contracts. The guidance has since been updated, and it says that contractor employees don't have to be fully vaccinated on the day of the deadline, as long as the company is making good faith efforts to ensure full compliance with its employees. And they even offered an example of how the federal government generally does it, which is a course of counseling, some persuasion, and ultimately it gets to the point where it becomes a disciplinary problem and the employee can then possibly be terminated. So that possibility has been expressly addressed now by the government in the guidance. So I think it's going to be a bit slow in terms of enforcement. I think that the administration is probably dedicated to this. I'm not sure they can totally walk this one back. With the infrastructure bill, you're right. It brings up an interesting question. If I have my way, which means there's going to be a lot of construction happening real soon, that means there's going to be even a bigger demand for workers. I can see a scenario where the employers are eager enough to get those federal dollars that they are unwilling to accede to employees' demands that they not be vaccinated, and they eventually will be able to find enough employees who are vaccinated who can do the job. Now, whether that bears out, it's very tough to say. In skilled trades, that may be a little different,
Right.
particularly depending on how highly skilled the trade is.
Yeah.
But for general construction projects, laborers, things like that, I don't see that being a huge problem.
Well, it's been so interesting getting some in-depth knowledge. I think the key takeaway for everyone, including myself, is that the deadline is no longer December 8th or
That's
January 4th.
Also correct.
So our new deadline is, you said?
January 18th.
So if everyone takes nothing else away, please take that away. There's still time for contractors to get into compliance.
And, I think something that gets lost in this, and Alex and I were talking about this beforehand, and I think we mentioned it early on, but I think it bears mentioning here again at the end, is unless your contract has the new FAR or DFARS clause in it, you are not required to comply with these vaccination mandates. I think there's been a lot of panic about this because that was somewhat unclear. It's, once you start getting into the details of it, you have to know your way around federal contracting a little bit. But yeah, until your contract is modified, you can go about your merry way and do as you see fit. But just know that if you get a new contract, or if you get a renewal or an option or extension, as soon as that happens, you will be on the line for this.
Well, immediately after we finished recording the episode on November 30th, there were some changes. So Jake and Alex were good enough to join us today to give us an update on what happened. So we're recording now on December 7th with an update on those changes. Jake, can you tell us a little bit about what happened?
Sure. So just after we finished recording, the U.S. District Court in Kentucky issued a preliminary injunction against enforcement of the contractor vaccination mandate. It prevents the government from enforcing the mandate in any existing contracts in the states of Kentucky, Ohio, and Tennessee, which it wasn't particularly surprising to us. We were surprised that it happened exactly when it did a little bit. In fact, Alex sort of sent me an email as soon as we got off the recording and said, of course they did this just now when we finished up. But the more interesting question is that because it applies only to Kentucky, Ohio, and Tennessee, how that may affect interstate contracts. Plenty of government contractors have subcontractors in various states, depending on the type of work they're doing. The injunction is a little bit loose from the court. It says that it applies to contracts and covered contractor work or covered contracts in Kentucky, Ohio, and Tennessee. It's a little unclear whether that requires contractors who work in those states but are based in other states to comply or not comply. This will be an interesting question if a challenge arises about this. We haven't seen any yet. Just a few days ago, the Department of Justice did request a stay of the injunction, basically to dial back the injunction. That has not been decided yet, to the best of my knowledge. Maybe they'll do it later today if our record holds true. So that's where we are. That's the new news on this. Otherwise, in the other 47 states and the territories of the United States, the vaccination mandate is still in effect.
Yeah, so it'll be interesting to watch and see how this continues to play out. And if there are further changes, where should a contractor look to make sure they're up to date on what's happening with this? Or should they reach out to their construction attorney?
Well, yeah, there are two ways to do that. One would be, as we've mentioned before, regularly check the Safer Federal Workforce Task Force guidelines and FAQs. Those are updated fairly regularly. That's where the general updates will be. As for litigation updates, there's no real single source for that. Watching the news is a good way to do it. You can also contact your attorneys if you have questions either about where certain litigation might stand, or if you need some assistance, that may be another route to go as well.
And Jake and Alex, if they want to reach out to either of you for more information, how can they do it?
They can reach me by email. My email is jwscott@smithcurry.com. And my bio is also available on our website, which is smithcurry.com. And my contact information is on there as well.
Perfect. And Alex?
The same is true for me. So if you just go on smithcurry.com, Curry with a U, our bios are up there. Alex Gorelick under G, and my email is agorielik@smithcurry.com.
Well, thank you guys for coming back and giving us this update. Maybe we'll have to have you back again in the new year to talk about where things are then.
That would be great. Thank you, Kat.
Thanks for being with us.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just want to say thank you again to Nationwide for their generous support of this episode of Let's Get Surety. For more information on Nationwide Surety Solutions, visit nationwide.com/surety.